Um, Welcome to the real estate section presentation for the Beverly Hills Bar for January. My name is Howard Gould. I'm a co-chair of the real estate section and very pleased to be bringing you another presentation with our speaker, Jana Gardner from the California Association of Realtors. Before we begin, I want to let you know that you'll be getting your MCLE certificates shortly after the program. You also will be invited to respond to a survey, and we'd like to get back your responses if you could give those to us. Also want to let you know that next month's program will be our annual review of last year's real estate cases decided in California, presented by Larry Jacobson, who also does that for CEB. We're going to have a program in March on real property taxes. And after that, we're looking at some programs that may involve HOA issues, 1031 exchanges, and some other programs that are in the works. Finally, I will be trying to monitor the questions, probably mainly in Q&A, and present those to Jana during the program if it's appropriate, or if we have time, we'll do those at the end. It's a great pleasure to have Jana back with us. She spoke for us in July, and we're having her back so soon because CAR has their new residential purchase agreement form that became operative really in December, and there's so much interest in it. We're very happy that Jana could make time to come back and join us again. She has been with CAR since 2014. Excuse me, primarily focused on advising members through the legal hotline, as well as presenting legal update outreaches and teaching classes on disclosures and the residential purchase agreement. She also prepares legal resources such as the legal Q&As and quick guides that CAR puts out, and co-hosts CAR's Legal Matters podcast and presents the monthly Legal Tools Talk on CAR's Facebook page. Prior to joining CAR, Jana spent over 3 years at Cox, Castle & Nicholson as a finance attorney, working with clients ranging from national banks and insurance companies to small private lenders on real property secured financing transactions. And her bachelor's degree is in social science from San Diego State and her law degree from USC. Jana, thank you so much for joining us.
Thank you so much for having me. Like you said, I was here a few months ago, but I'm very happy to have the opportunity to be back now. Like Howard said, the new RPA, the CAR Standard California Residential Purchase Agreement, is now live. It went live about a month ago. I believe you were all sent a sample copy of the RPA. Hopefully you got a chance to check that out. You know, if not, we'll be going over it today. I'm not going to be going over every single change that was made, as you'll see. I guess I can start sharing my screen here. The changes are pretty significant. I will say that it looks more different, I think, than it actually is. There are significant changes, but a lot of sort of the for better or worse, the functionality of the contract and the transaction remains largely the same, time periods, things like that. But it does look very different. So that's sort of been the big thing that everybody is getting used to. Here. So the first major difference you'll notice is it's gone from 10 to 16 pages. I talked to people who've been in this field a lot longer than I have, who will say, I remember when it was 1 page, I remember when it was 2 pages. When I started at CAR almost 8 years ago, it was 8 pages. So it has doubled in just my time at CAR. It went from 8 to 10 and now 10 to 16. So a lot of that on this form is formatting related, as you'll see, although there are some new provisions as well. The biggest structural change is that now all negotiable deal points, all modifiable terms are located in one paragraph, in paragraph 3, that we are sort of anecdotally referring to as the grid. Not its official term, but just sort of the terminology we've adopted. I'll show you what that looks like on the next slide. The idea being that to make it a little bit more user-friendly, a little bit easier for consumers, buyers, sellers to review the deal points and compare offers against each other. And then also to prevent people who maybe aren't as detail oriented or read the entire contract through with a fine tooth comb, as of course they should be doing, from missing terms or time periods or other things that were changed throughout the contract as a whole. So now everything is located up front. And like I said, I'm not going to be able to go over every single change today in the contract. Takes me 4 to 8 hours to do that in the classes and seminars that I teach. But in the hour today, I wanted to focus on some of what I think are going to be the most legally significant changes to terms and procedures. I'm going to be focusing on the new procedures relating to assigning the contract, dealing with tenant occupied properties, what happens to abandoned personal property after the close of escrow, the notice to perform and cancellation process, the cancellation deposit dispute, sort of release language in our cancellation form. We'll look at that also. Some new procedures, some new optional procedures for delivering notices and documents during the escrow period, a new option for choosing an arbitration provider in the arbitration clause, and a new setup for dealing with entity buyers and sellers and legally authorized signers and some, I think, new and improved signature blocks. So that's what I'm going to be focused on. Like Howard said, he'll be jumping in with any points he wants to add or questions he wants to ask me. If I skip over something, go ahead and bring it up anyway. Or we can also, like you said, get to it at the end. I think we'll have a little bit of time to do that.
One comment to begin with is that there's a link to the a sample of this residential purchase agreement in the chat window. And but the outline that Jana is using has not been put in the program materials.
Yeah, and really my materials, it's just zoomed in pictures of the contract for the most part. So this is more just to help the flow of what we're going to cover today than anything substantive beyond what you'll find in the contract. Although I do have some snippets from some of the referenced forms as well, that if we want to provide supplemental materials, I'm sure there's a way to make that happen. I'm happy to share anything further after the program. All right, so this is just a look at, like I said, the grid. So you can see this is paragraphs 1, 2, and 3 of the contract that make up the first 3 pages. Paragraph 1 is largely the same in that it identifies the identity of the buyer and the subject property, but now where you used to find the purchase price and close of escrow, that is moved down to paragraph 3 with all the other deal points. And then paragraph 2, agency, also largely unchanged. There's some clarification language in there to help explain the agency disclosure requirements, what is and is not required by that law. But otherwise, it still just has the agency disclosure and then the statutory agency confirmation language as well. And then paragraph 3, this first section that makes up the bottom half of page 1, has your purchase price, your close of escrow date, and a moved up line item for establishing the date of the expiration of the offer. That was a term that was previously on basically the very last page, right by the signature lines. Now it's front and center, so the parties can see right away when this offer expires and not lose track of when they need to respond to the offer, accept or respond if that's what they're going to do. And then the remaining section, just dealing with the structure of the financing for the property, the initial and optional increased deposit, and then breaking down the loan amounts, the loan types, and then also here a designation for the occupancy type, something the lender wants to know. Is this going to be the buyer's primary residence, a secondary home, or an investment property? And so one thing I wanted to note here before I moved on about this structure, just to be doubly clear about it, this isn't a summary, right, of the terms of the contract. These are the contractual terms themselves. They're just all in here, and you will see references. So, this is paragraph 3A, 3B, 3C, and then under paragraph number, these references are to the further down paragraph in the contract that has additional substantive terms about these negotiable items. So, we have our initial deposit amount and deadline. And then when you go to paragraph 5, there will be additional terms about making sure the deposit is put in with escrow on terms escrow deems acceptable and things like that. And so anytime you see one of these, references, that's where additional information is located. My understanding is that the dream is in the online forms platform to have a way to sort of easily click back and forth. I'm not sure the tech people have gotten that up to date yet, but I think ideally you'd be able to click here, go and see what that additional language is and comes back. I think that's still in the works. And then we're going to get into more detail, but just, going through, you can see this has everything from time periods, contingencies, terms of possession, deadlines for providing documents or other compliance issues, items included and excluded, and then also our allocation of costs section as well, all in here. So I'm going to jump to page 2. A few things on here. One added line item right up the top where the buyer can ask the seller ahead of time for a credit. Some buyers who are particularly financially tight in making their offer, maybe they're FHA, VA, or maybe they just, have put every last cent they have into their down payment. If they know they're going to need help covering closing costs, the feedback we received is that was a very common custom clause that people would write in. So there's now a line item for it, completely optional. If the buyer wants to ask the seller for any closing costs or credit that would be applied to closing costs, they can do it there. Another difference is that all of the verifications for buyers' financial qualifications now default to being attached to the offer, not get your offer accepted, provide your lender pre-qual letter 3 days later. But that seems to be the expectation now, is that buyer, you better have all of that attached to your offer for the seller to review and verify ahead of time. And then this brings me to the first point I really wanted to highlight, which is a new time period for the buyer to make an assignment request. So in the previous version of the contract, our old assignment paragraph was pretty bare bones. It basically said, buyer cannot assign this contract without seller's written consent to a specified assignee, and that consent shall not be unreasonably withheld. And that was all that it said. And what we started to hear about from specifically listing brokers was that they were seeing a lot of last minute fire drill assignments happening on the eve of closing that they were finding very disruptive, whether it was sort of what you might think of as a traditional assignment, someone stepping out and assigning to a business partner, or even receiving compensation to assign the contract and have somebody come in, or really what we see a lot of are partial assignments where maybe the buyer can't qualify for the loan, and so they want to add a family member or some other person to the deal so they can get the loan and close it. Doesn't have to be the biggest deal in the world, but when that request comes 2 days before closing, it can be a little bit hectic, and whether or not seller would be reasonable to withhold their consent to something like that was a bit of point of contention.
Jana,
So
the case that you're talking about where the lender comes back and says you need a cosigner, how are you going to know that in the first 17 days? That's going to be a problem, isn't it?
It could be. I know in that example that the 17 days may or may not be an issue for people. I mean, hopefully they get that process started pretty early, but I think we do all know that lenders operate on their own time schedule. And so, there's probably a reason why that stuff comes up at the last minute. And I will say, of course, a seller can still choose to consent and say, sure, let's do it. But this is pretty protective of sellers now, creating this time period. And so, as you can see, it references paragraph 23, which is the actual paragraph that lays out the assignment provision. So I'm going to go ahead and jump to that paragraph so we can take a look at it, because there are some big changes here. One of the good changes for buyers is that it now specifies that seller's consent is not needed if the buyer is assigning to their own trust or a wholly owned entity. So if the buyer just basically has decided they want to take title in a different fashion than they were planning, and they don't want to take it as an individual, but they want to put it in their trust or some wholly owned entity that they have, then they don't need seller's permission or consent to do that. They can basically just assign it and tell the seller that's what's happening. But if there is going to be a third party being brought in, either for a full or partial assignment, The buyer's required to disclose the identity of that assignee and any monetary consideration they're receiving. That new third-party assignee is required, well, they need to be delivered all of the prior transaction documents, disclosures, contract documents, everything like that. And they need to initial and return those documents to confirm that they received them. And all assignees, whether it is a, fully owned trust or sorry, a trust, a wholly owned entity, or a third party, all assignees need to provide the same pre-qualification or pre-approval as the original buyer. If there's a lender involved, to say, hey, yes, I was approved as an individual, my entity is approved to get the loan as well, or if it's a third party, that they're qualified. And then now we have this 17-day time period where if the buyer does not put in this request with the required information by day 17, beyond day 17, seller's withholding of consent will be deemed reasonable. So it's a pretty, tight time frame there. It, of course, like all of our time frames, can be extended. It could be shortened. It could be lengthened if there's any concern about that. As you'll see in a second, our loan contingency is now also 17 days. So the time periods are really short on across the board here. And so it lines up, for the rise at 17 days, it lines up with the contingency periods, is essentially the reasoning behind that.
One of the comments, Jana, about this form is that it appears to me to have been drafted with the market of the last few years in mind, where sellers have a dramatic upper hand. We're wanting people to attach their verification of funds. When we get into markets where the buyer has the upper hand, and especially if there's carryback financing, you may find that your seller is not happy with this first sentence, where the buyer assigns to some company that has zero assets, but they happen to own it, and the seller can't complain. And now they've loaned a lot of money on a carryback financing. And if there's a default, it doesn't really directly hurt the credit of the person they thought they were going to be lending the money to, but instead some entity. So
Sure.
we have a form that maybe reflects the current market of the last few years, that when the market changes, sellers and buyers both may want to be doing a lot of modifications here.
Right. And I think your point about the added issue for seller financers is well taken, that if a seller is going to be offering seller financing as part of the deal, they may want to consider making some modifications for that as well. But I think you're right. Just a little history on this form. It's been in the works for a long, long time. It was originally scheduled. I think the working group to update the contract was formed in 2018, and it was originally scheduled to be finalized and released in 2020. But basically, when the pandemic hit, the decision was made to push it a year because we didn't want to hit our realtor membership or buyer and seller consumers with a brand new contract in the middle of the chaos of the pandemic market, which turned out to be even more chaotic than I think we expected it to be. And so, like I said, it's been in the works for a long time, but I do think, it continued to be changed up until early 2021. So although I was not in the forms committee meetings, I'm sure some of that is reactive to the recent trends we've seen in the market. That tends to play a part in these decision making for sure. And then I just had don't want to spend a ton of time on it, but I just wanted to show you, this is what our assignment of agreement addendum looks like, the AOAA form that basically tracks everything that was in that paragraph 23 in terms of, identifying the assignee, dealing with the delivery and return of prior documents, delivering with the pre-qualification and pre-approval, disclosing any consideration, and then acting as an assignment and having the seller's consent when that is required as well. So that is the assignment of agreement addendum form that the parties can use for that purpose. All right. So I'm jumping now a little bit further down in the grid to paragraph 3L. This is something I mentioned earlier, a change that I personally really like, which is listing out all the contingencies in the contract in a single place. Often in my conversations with brokers and agents, they sort of refer to the contract as if it has 3 contingencies: loan appraisal and inspection. And I know those are the ones that they focus on quite a bit, but a lot of them either maybe don't know or just don't really process the fact that the contract has at least 5 contingencies and maybe more, depending on the circumstances of the property and the transaction. So instead of having, just, throughout the contract, language, that the review of the preliminary report is a contingency of the agreement, or the common interest development documents, these are all now laid out here with all of their time periods, which have been uniformly set at that 17-day time period window that is, of course, modifiable, can be lengthened or shortened by the parties involved. And for the contingencies related to reviewing documents, it is specifically 17 days after acceptance of the contract or 5 days after delivery of the documents, whichever is later. So make it a little bit clearer that you can't give someone documents at the last minute, force them to remove the contingency immediately, 17 days or 5 days after receipt, whichever is later. So every contract is going to have the loan appraisal, investigation, review of seller documents, which is the statutory and supplemental disclosures, as well as any other reports the seller is obligated to provide, then review of the preliminary report from the title company. And then if applicable, if the property is located in a common interest development, review of the HOA documents. And if there are any leased or liened items on the property, like leased solar panels, or maybe a PACE or HERO loan for an HVAC system or some other unit on the property, then that's a contingency as well. And then finally, optional, if the buyer needs to add a contingency for the sale of their property. Speaking of the competitive market, not something we're seeing a lot of in accepted offers these days, but as the market turns, we see differently. So if the buyer wants and needs to make the contract contingent on selling their current property, that's the place where they're going to do that and attach a whole separate form with its own time periods and obligations built into it. A couple of things I wanted to highlight here. Like I said, the loan contingency is now a very short 17 days. It can be changed, but it is now uniform with everything else. It used to be 21. You used to have the option for the loan contingency to stay in place through the funding of the loan, but that also went away a long time ago. And then a couple of significant changes here to the appraisal contingency. The biggest being that there is now an option to set the appraisal contingency at a dollar amount different than the purchase price. So basically saying that, if you change nothing, it works the same way it always has. The contract is contingent on an appraisal coming in at the contract price. But speaking of maybe changes that are related to trends in the market, what we've been seeing a lot of over the past couple of years is agents writing in what they call appraisal clauses or appraisal gap language, where they would say something like, if the appraisal comes in low, buyer to pay $10,000 over appraised value. And then there would be a huge fight over what that meant when the appraisal came in $50,000 under the contract price, because that's the kind of thing we were seeing over the past year, going on 2 years now. And, with that language, the buyer would say, well, seller, you have to reduce the price. Seller would say, I thought you were just going to close the gap. That wasn't my intention. And so, now there's an option. If really what the buyer wants to offer is to say, I'll close a gap of up to $10,000, then they can set the appraisal contingency at a slightly lower amount. Say the contract price, they're writing the offer at $500,000. They can say the agreement is contingent on the appraisal coming in at $490,000. So that way the buyer, as long as it comes in at $490,000, the contingency is satisfied, and they're going to bring in the money to close that gap, a way to make their offer more competitive, which is usually the point of those clauses, without setting up everybody for a big legal dispute over vaguely drafted language down the road. And then the other additional clause that's just added here is also based on something we've been seeing, which is a reference to the amendatory clause that goes into the contract for FHA and VA borrower buyers. So if you're not familiar, the FHA and VA underwriting requires FHA and VA borrowers to have in their purchase agreement this amendatory clause language, which is on our FVAC form. That's what that's a reference to. that says, notwithstanding any other provision of the agreement, if the appraisal comes in below the contract price, the buyer can cancel and get their deposit back. And so what we were seeing was buyers, FHA, VA borrower buyers, putting on the contract, oh yeah, I waived my appraisal contingency, but then the amendatory clause is included, everybody would sign that, appraisal comes in low, and then there would be confusion about what the buyer's rights were. So there's clarification language here reminding the parties that, if you read that amendatory clause, that is still in the contract, regardless of what you do with the appraisal contingency. And then final note before I move on, we also moved up here the reference to the buyer's right to access the property for informational purposes. That's been in the contract for a while. It used to be down in paragraph 14. And people just seem to miss it a lot. They didn't realize that, just because the buyer might have waived their inspection or investigation contingency, they still had a contractual right to access the property. They just waived their right to cancel based on the result of any inspections or investigations. So that's been moved up here also for clarification purposes. Okay, still in the grid, quite a few things here I want to note. One of the biggest has to do with delivery of possession of the property and a new way for handling selling tenant occupied properties. That is something I can tell you is absolutely related to issues we've been seeing over the past couple of years. First, obviously, with the passing of AB 1482 and the Tenant Protection Act all the way back in 2019, that made dealing with tenants more complicated for many property owners all over the state, if not all of them. Then we were hit with all of the COVID-related rental restrictions, tenant protections. And really what we just saw was, again, kind of chaos with people thinking, oh, I'll just get my tenants out of the property and sell it, when it's rarely, if ever, that straightforward. And so I'm going to go through this page, and then I'm going to show you we have a new form called the Tenant Occupied Property Addendum that addresses issues for selling tenant occupied properties. The previous default was just, if it's tenant occupied property, the property will be vacant 5 days prior to closing. Easier said than done. And so now we have some more nuance into how that situation is handled. So whether or not the idea is for the tenants to vacate prior to closing, any property with tenants in it at the time the offer is being written should include this tenant occupied property addendum. We also have more specific language, basically requiring the parties, if they're going to agree for a seller to remain in possession after closing, to attach the appropriate form, a seller license to remain in possession for up to 29 days, or a residential lease after sale if they're going to remain in possession for more than 30 days after closing. We've been seeing too many offers that just say, seller to remain in possession for up to 45 days. No additional terms, no additional documents. So really trying to guide people to protect everybody's interests by having the appropriate forms. One other new deadline here has to do with installing the California health and safety required retrofits, smoke alarms, carbon monoxide detectors, and water heater bracing. There's already a requirement for that to be done prior to closing, and for most sellers to certify that as of closing, those items will be in compliance. But buyers, lenders usually need them in compliance earlier at the time of the appraisal or an inspection. And so there's now a deadline to make sure those are done, which hopefully they already are on the property, but if anything needs to be installed or updated, it needs to happen within the first 7 days of the contract. And then finally, on this section, paragraph 3P, we have added many, many more checkboxes for negotiable items that can be included in the sale, based entirely on, over the years, what we've heard people getting in fights about or disputes about what's included or what's not. Some of these things didn't exist, or at least didn't exist with any, in any common fashion the last time we updated the contract 7 years ago. So now we have check boxes for video doorbells, electric car charging systems, whether you want that to stay on the property or not, as well as all of the appliances. Some of these might seem a little bit silly out of context, but I can't tell you how many people have called me to ask if a wine refrigerator counts as a refrigerator. So now we have some specificity. You can say specifically if you want sort of a traditional refrigerator, or if there's a wine fridge, you want that included as well. Above ground pools and spas are often a point of contention. And then the one that comes automatically checked here is bathroom mirrors. I got a hotline call about this literally 2 days ago, where the buyer moved in and the seller had taken the bathroom mirrors, and the buyer was very upset. And it usually would boil down to, well, were they affixed to the property or were they hanging on a hook, personal property, and the seller carried them away? Now the default is just, seller, you can exclude whatever you want, but unless you exclude it, the bathroom mirrors are staying on the property. So before I move on, I wanted to take a look, back up a little bit to the new provisions of that tenant occupied property addendum. I'm going to show it to you here. The biggest change is that the tenant occupied property addendum, instead of defaulting to the tenant being out prior to closing, now defaults to the tenants remaining in possession unless the parties agree otherwise, and specifies what happens if the tenants don't get out. So if nobody checks anything, the parties are agreeing that the tenants will remain in possession after closing. Now, most buyers, I shouldn't say most, but a great number of buyers are probably buying the property to own or occupy. And if that's the case, or whatever their reasoning is, they can still absolutely check the box in 1B on this addendum and say the property will be delivered vacant. If there's more than one unit, you can specify which unit. If it's like a duplex and the buyer is going to occupy half, you can specify which unit you want to be vacant. And the default is the tenants will be out at close of escrow, or you can check a box for 5 days prior. But the biggest difference here is actually having some procedures in place for what happens if the tenants don't leave, because that has been a major issue for people. The tenants just don't go, especially when the COVID protections were in place and everyone's hands were pretty much tied. No one really knew what to do, and it would be potentially very complex and lengthy legal disputes. And so now buyer's remedy, as spelled out in this addendum, if the tenants don't leave and the seller has acted in good faith, done everything they can under the law to get the tenants out on time, which of course, there may still be some room to argue if the sellers acted in good faith and did everything they could under applicable law. But if they did, then buyer is going to be left with the option to choose to close with the tenants in place, or the buyer can cancel and get their deposit back and be reimbursed for their reasonable out-of-pocket costs and expenses. So hopefully avoiding tying up the property indefinitely while an eviction maybe does or does not play out, just letting the buyer decide, do you want to close with these tenants, or do you want to walk away, get your deposit back, get reimbursed for the money you spend on the transaction, and move on. So that is a big change there.
Just a comment, Jana, but given the fact that, residential buyers, especially first time, they're expecting to occupy, it seems a bit of almost a trap that if you don't check a box, you aren't getting possession of the property on the day it closes. So somebody who, represents the buyers at times, that seems a big danger to buyers, that if I don't check a box, and also a risk to your agents that that person could, on close of escrow, find they don't get possession and they aren't entitled to it.
Yeah, it's going to be something very important, I think, like you said, for buyers agents to be aware of, be advising their clients of, and making sure that they are asking for that if that is what their buyers need. It's, like I said, one of the big risks and issues with, selling tenant occupied property in general, but yeah, it's going to be something that they're going to want to be really on top of and hopefully are aware of. All right. Okay. One thing I wanted to note here pretty quickly. So that was it for the grid. And if we have questions about other sections of it, we can absolutely circle back to those later. But I wanted to highlight in paragraph 4, this new sort of concept that we have in the purchase agreement about property type addenda. So up until now, we basically had 4 types of residential contracts. We had the RPA, the residential income purchase agreement for specifically for investment properties. And then we had the probate purchase agreement and the manufactured home purchase agreement. But the thing with those last 2 is they basically just were the standard RPA with 1 to 2 additional paragraphs added to address probate terms or manufactured home issues. So the decision was made, instead of continuing to replicate the contract with those small changes and have sort of those mostly duplicative contracts out there. Instead, now the base, and also to address the fact that you could have a probate transaction, for example, that wasn't residential. And we didn't have an option for that until now. And so now what we have is the probate agreement purchase addendum and the manufactured home purchase addendum, which can be attached to any of our purchase contracts, whether it's the residential one or any of the others that apply, and basically add probate terms, court confirmation, dispute resolution, things like that, or manufactured home, mobile home terms, things to do with the manufacturer, park approval, those sorts of procedures. So those are 2 changes we made to how the contracts work. Already talked about the tenant occupied property addendum. And then there's 2 brand new property type addenda that were created more or less at the specific request of brokers from certain regions where these transactions are very common. I think, well, specifically with the tenancy in common, that's much more of a San Francisco area issue, where you're more likely to have a buyer purchasing into a tenancy in common relationship. That addendum and the many documents that go along with it are incredibly complex. And it basically says your buyer client better have an attorney who's handling this for them, more or less is what it says in that form. References to the need to have a separate TIC agreement. There's financial disclosures, things like that. But there's at least now a way to incorporate it into our contract. And then if the buyer is buying into a stock co-op community, common interest development that's just a stock co-op, then we have an addendum to deal with that as well now. So again, those have been being requested for years, and those are now options. And the tenancy in common one in particular is very complex, and I would never advise a realtor to sort of just like throw it at their client. And the form itself does just say, talk to an attorney, basically all over it. And then the rest of these are nothing really new, just addenda and advisories that may apply in the transaction with some pre-checked, because that's what comes automatically bundled to our contract. So I will say these pre-checked items like the buyer inspection advisory, wire fraud advisory, CCPA, those are pre-checked. They come auto bundled when a agent or broker pulls up our contract in any of the online forms programs. Anything else that has a checkbox, at least if they're using one of these online forms programs, it should auto attach it. The idea is, they check the realtor checks this box, it attaches that form to the transaction to hopefully make that process a little bit easier for them. Okay, skipping down now to page 5 and paragraph 7. There is new procedures in place for dealing with a situation when sellers leave behind personal property after closing. So up until now, the contract has always just said that all debris and personal property not included in the sale shall be removed by close of escrow or when possession is delivered to the buyer. And then we would hear about after closing, the seller just leaves stuff behind, either because, oh, they're going to come back and get it and they haven't finished moving, or because they just didn't want it anymore and they decided to leave it and make it the buyer's problem instead. And so now we actually have language addressing what's going to happen when that situation arises. The new language says that if items are not removed when possession is delivered to buyer, those items are deemed abandoned, and buyer has the right basically to first deliver to the seller a written notice, basically giving them 3 days to come back and get the personal property. And if the seller doesn't do that, the buyer can have the property removed, and if they incur expenses, go after the seller for reimbursement for any expenses they incurred, having to clear out the items that the seller's left behind that nobody wanted anymore. So, and we don't have a form, just so you know, for that. We do have a sample letter. That's one of the features we provide to our members, or we have these sample letters that are just like optional letters they can use to help their clients convey information, but any written notice could be used to say, seller, you left these items behind. come and get them. I will address the question that I saw pop up in the chat, because it is the obvious and inevitable question that this provision raises, which is, how does the buyer track the seller down? Fair point. Typically what the buyers do, in any time there's a dispute after closing, and this would just now fall into that arena, typically what happens is they send communication to both the listing agent and to escrow, with the hopes that that information is forwarded on, which tends to work. In my experience, people forward the information onto the seller, even if they say, I'm not involved, but here's a letter I got that's addressed to you. And part of what we have in our sample letters is a way for a listing agent to basically respond and say, I am passing on this letter, but please remember, I'm not the agent anymore. This transaction is closed and I'm doing this as a courtesy. So trying to give a practical option there without forcing any agents into a situation they don't want to be in post-closing.
Jana, just to, first of all, that's a great question. And for those of us that ever deal with this, you may want to put in something that says, you know, the post-closing notice address for the seller. Also, I wanted to comment on 7D here. It's good to see that CIR has added that warranties are to be delivered that are available. I also, when I've done these things in the past, would add in that they will deliver any plans and specs they have for construction that was done. Is something you may want to add in, so that if the seller has the plans, the buyer gets them.
Excellent, thank you so much. All right. Okay, so jumping now to paragraph 9 on page 6. This is the paragraph dedicated to items included and excluded. We looked at the check boxes that were in 3P. And then these are the items that are included, you know, regardless of what's checked or not. So what I always tell brokers, agents representing sellers, it's really important to have your seller look at this ahead of time. Read this section, see if there's anything listed in here that they don't want to be included, so that it can be countered out, so that they can say, actually, I'm not including that. We have a note about that here, especially for sellers who might have hired stagers to come on the property and put, like, you know, nice furniture, which could include fancy curtains. Well, curtains are included per this paragraph, window coverings, which includes blinds, curtains, drapery, you know, things like that. And so, you know, really important for sellers to read this section. And if there's anything they don't want to have included, especially if they don't own it, then to make sure that they counter that out. Another big one that comes up and surprises people is that water features and fountains, water softeners, and water purifiers are all listed as included. So if the seller has some fancy water fountain that they want to take with them, or they really like their water softening system or water purifier, then they would need to exclude those if they don't want to leave them behind. And then I have a note here that's not super interesting, although realtors do ask about it. We get a lot of questions about, like, wall-mounted TVs and things like that. And our contracts always said, or at least for the past 7 or so years, that if a flat screen TV is attached to the wall via a bracket, you can take the you know, the seller takes the TV, that's not automatically included. Same thing if furniture is bracketed to the wall for, like, earthquake or child safety reasons. But there's a new provision that says, you know, if you do have something bracketed, seller, you know, you take it with you, you also take down the brackets and repair any damage to the wall, although you don't have to repaint. And that's just a new provision and something else for sellers to be aware of if they have a fancy wall-mounted entertainment system, flat screens, speakers, things like that.
I think it's also useful to note that 9A basically says, we don't care what we put in the marketing materials, don't believe them, because they're not included, they're not excluded. The only thing that matters is what's in the contract. So if you got marketing materials, basically this form is claiming that they are meaningless. Whether, you know, a court's going to agree with that is an interesting question, but that's what the form says.
Well, I think what how I would explain that section to people is to delineate the difference between what's included in marketing and what is a contractual term. Now, this doesn't mean that if a agent or broker advertises something that turns out not to be true, that they're just scot-free. I would never tell an agent or broker, just, hey, put whatever in your advertising, you're not bound by it. But I think more what this is trying to convey the differences, that doesn't necessarily create a contractual obligation on the part of the seller. And so just really encouraging people to be mindful that the contract is the agreement between the buyer and seller. And if you want to be able to hold the seller to this, as opposed to go after an agent for potentially engaging in false advertising, make sure you include what you want in the contract. Because you can see a situation, I don't know how common it is, where an agent advertises that the appliances are included, but maybe the buyer doesn't even want them. Maybe the buyer loves their own appliances, so they just, they're not going to ask for them to be included. So we're always trying to bring people back to what's in the contract, is the idea behind that section. That's been in the contract for a little while now, but is trying to guide people into getting things in the contract and hopefully avoiding even having that dispute down the road, although it does still happen. All right. Paragraph 11 here, this is our disclosure paragraph. Really just highlighted this section as a callback to when I was here a few months ago to just point out that yes, the disclosure section of our contract does now include references to the new fire-related disclosures for properties located in high and very high fire hazard severity zones, new statutory disclosure requirement related to home hardening features on the property and defensible space. And we have a new form that talks about all of that. I talked about that when I was here 6 months or so ago, but since the purchase agreement has been updated, the purchase agreement now refers to that newest disclosure obligation that went into effect over the course of 2021. And then we also have some very specific language here in 11A2 that tracks with the language from the civil code, from the TDS law in 1102, that the civil code spells out when the TDS is considered completed, which is when sections 1, 2, and 3 are complete. And we just basically repeat that here to make it very clear to both sides, and maybe nudge the seller and the listing agent a little bit to say, the transfer disclosure statement is not considered complete until section 1, which requires you to check a box about substituted disclosures, section 2, the seller's information, and then section 3, which is the agent visual inspection disclosure for the listing agent or broker. All 3 of those sections have to be complete for the transfer disclosure statement to be considered complete. So we're just highlighting that so that hopefully they don't leave those things to the last second and create unexpected issues, potential cancellation rights, since a late delivery of a transfer disclosure statement can open up rescission, cancellation rights, even without any contingencies in place. All right. Oh, and that's what I'm talking about here. This is further down in the disclosure paragraph. And just another note that the disclosure paragraph has been reorganized a little bit to really sort of specifically lay out all the required disclosures in one place. We now have explanations about the home fire hardening and defensible space requirements and what those entail. And we specifically lay out the termination rights related to these documents. Like I just referenced, if a statutory disclosure is delivered late or is updated or amended during escrow, you have this 3 to 5 day window, depending on the method of delivery of the new disclosure, where the buyer can rescind and get out of the contract. And then we now also have a provision saying that if the parties can't agree on the defensible space compliance issue, either, if the seller doesn't have the documents and they want to say, buyer, we're going to shift that responsibility to you. If they can't come to that agreement, then the sellers could say, buyers, if you don't sign this and agree to take on the responsibility, notice to perform and cancellation if it comes down to that. All right. Paragraph 13 is our title and vesting. We have language up in 13A that talks about buyer being provided with a preliminary report, and that a review of that preliminary report is one of the contingencies of the contract. Very important for the buyer to review that. Howard and I have spoken a little bit previously about how, it's, I think, really hard, especially for your average first-time home buyer, to review a title report and really know maybe what they are looking at. But we do advise them to, review the report, review the underlying documents. Properties taken as is. The only thing that the seller's obligated to clear are monetary liens of record. That's all the same as it has been. The new provision here in 13E has to deal with geographic targeting orders, basically putting the buyer on notice and obligating them if a geographic targeting order applies to them in their transaction. So if they're in one of the counties where these GTOs exist and they're an entity and they're paying cash of at least $300,000, the buyer is obligated to work with the title company to provide the required information and satisfy those requirements. And that's just another thing that didn't exist the last time we updated the contract. So there's a reference to that now.
I think this is a good point. You mentioned something that I saw as missing in this agreement about when they start talking about title, and also it really has to do with inspections, but nowhere in this agreement does it mention the buyer getting a survey, or I don't think the word survey is in here anywhere. So if you're representing a buyer, it's something that you're going to have to add to the equation so that the buyer understands what a survey would show them and whether or not they want to get a survey.
No, very, very good point. And there's references to surveys in some of those buyer advisories, like the buyer inspection advisory or statewide buyer and seller advisory. But that's a lot of paperwork that people don't necessarily read. So I completely echo that advice that if you are working with a buyer advising one, definitely a good idea. And that's the kind of thing I skipped over the allocation of cost section because there really aren't any changes there. But that's the kind of place where you could either write in if there's if you want to ask for a seller to take on that cost, or even just write in that the survey is going to be taking place. That is somewhere you could do that.
Jana, since you brought up allocation of costs, there's two other things I wanted to mention to everybody that I was surprised to see in here. Generally, at least in Southern California, the seller paid for the buyer's title policy, and the buyer would then pay for their lender's policy. This form makes that optional either way, and you have to check a box. And it's in this hot market, it's an invitation to sellers to stick another big expense on the buyer. And not only does it say that for the title policy, it also says that for all the county and city taxes, which traditionally here a seller would pay for. And now this form basically says you have to make a decision. And again, it's an opportunity in a hot market for the seller to say to the poor buyers who are really in a tough situation the last couple of years, oh, here's a really big expense we're going to put on your back. So you need to look at that and see that those are now, you have to check a box to allocate things that traditionally in this area were the seller's expense. Yeah.
No, absolutely a good thing to double check. And it does vary. And one of the issues with our statewide contract is that regionally, these things can be different, but I definitely see the same thing you do, which is typically seller expenses, but in a hot market, everything's up for negotiation. And so it's tough to be a buyer out there, I think is understating it.
Unfortunately, this form really, that's why I said earlier, it seems to have been drafted with this hot market in mind, and I don't think it's particular buyer friendly in those respects.
Yeah. All right, just a couple more things. I know we're already at 1:26. This is flying by. So let me just go through. I have just a couple more things I wanted to note, and then maybe we can get in a couple of questions at the end for things we skipped over. One thing to highlight here, this is in paragraph 14, where we spell out the seller and buyer rights to cancel, which are basically good faith exercise of any non-waived contingencies, and then failure of the other side to perform. And one just very small addition that I think is pretty legally significant is that in the previous version of the form for the seller right to cancel based on buyer failure to perform contract obligations, it listed out specifically, which obligations existed in the contract, which it still does. But now there is a catch-all for buyer's failure to perform any additional buyer contractual obligations included in this agreement. And same thing on the seller side. If seller, fails to deliver documents or has not performed any seller contractual obligation included in this agreement. So it basically is a broader right. if one side or the other can sort of catch the other side missing a deadline, not performing for a contractual obligation that has a deadline attached to it, to give a notice to perform. And if they still don't do it, cancel on that basis. So just something for everybody to be aware of, that, you know, especially in a hot market, if people are looking for ways out of a contract, you have to be very, very mindful of all deadlines. I think people think, oh, removing contingencies. There's a lot of other deadlines in the contract as well that could give rise to a cancellation right if someone fails to meet that. Oh, and then just as the notice to perform, a couple things here. Notice to perform language, we added, there used to sort of be, I don't really think ambiguity, but the contract didn't address it. Because our contract requires giving a notice to perform before canceling on the other party for failing to perform, but we have rules about how and when it can be delivered, and what if someone doesn't deliver it properly? They don't give enough time, or they send it way too far in advance. You know, can they just say, oh, well, we'll wait and cancel later anyway? Now, specifically, we state that if the notice to perform is delivered improperly, if it doesn't give enough time, or it's delivered prematurely, that notice is valid and invalid and void, and has to be redelivered properly to allow for cancellation in the future. And then a change about escrow and deposits down in 14H here. So for a while, we were trying something where we had this provision in this section of the contract that said, you know, if the other side doesn't release the deposit, you could issue a demand for release of deposit to the escrow company. And if there was no response from the other side within 10 days, escrow was empowered to just release the deposit without mutually signed instructions. Well, turns out escrows didn't really go for that. And very few escrows, if any, agreed to honor that provision. They basically said no, require mutual cancellation instructions no matter what. So that's what the contract went back to saying. Mutual cancellation instructions are required for the seller, or excuse me, for the escrow to release the deposit to either side. And then we still have language about the potential civil penalty for bad faith retention of the deposit, refusal to release. But we also have an advisory saying agents and escrow cannot advise a buyer or seller about what constitutes good faith or bad faith withholding of the deposit, and the parties are advised to seek the advice of a qualified real estate attorney for that matter.
One thing to note on the notice to perform, some agents were in the habit of sending out the notice to perform before the date for performance even arrived, had arisen. You know, so you're supposed to perform on Friday and they'd send out the notice on Tuesday, Wednesday, whatever. This form actually allows for that and incorporates it. So even though there's a 2 or 3 day notice to perform, you don't really have to give the person time after the deadline, another 2 or 3 days. This form specifically incorporates this concept that you can send a notice to perform before the time for performance has even arisen.
Right, as early as 2 days beforehand. That's the earliest you can send it. So like you said, it's a 2 day notice, but if you want to hold them to the deadline, they can send that notice 2 days in advance so that it lines up with the contractual deadline. So an aggressive move, but something that they can do. All right. Oh, and this is just what the cancellation form looks like. There's nothing too earth-shattering different here, but we just added some additional language, again, sort of explaining the difference between canceling the contract and canceling the escrow, which is a concept that people struggle with sometimes, that someone might exercise good faith cancellation, but that escrow is going to stay open until both sides sign mutual cancellation instructions. And we basically have 3 options for dealing with releasing the deposit. Buyer gets it, seller gets it, or the parties agree to a split. All 3 of those come along with a full mutual release from any future obligations under the contract. And then we also have an option for a partial release and reservation of rights, where the parties agree and acknowledge that the contract is canceled and the escrow is being canceled, but that they're not agreeing what's going to happen with the deposit. They're reserving their rights to mediate, arbitrate, litigate relating to that deposit. Okay, almost done. Just a couple new things in what was our definitions and is now definitions and instructions section. A very common call we get on the legal hotline is people wanting to go over how to count the days. When is acceptance? How do you figure out your deadlines? So we now have a little sort of walkthrough with examples of how you count days. People are still gonna probably ask about that, but at least it's in there now. And then a big change about the concept of delivery. We now have the option, if the agents in the transaction want to go this route, they have the option of providing a designated electronic delivery address, an email address, essentially. It could be a cell phone number, but an email address, where they can authorize the other party to deliver notices and documents to that email address, and that notices and documents would be considered delivered upon being sent to that designated address. So the default is still, as it is in our previous contract, effective upon personal receipt, but people often struggled. You hit send, the other side gives you the runaround, you can't track them down, they won't confirm they received it. What do? There's now this option where, one side or the other can say, I do everything above board. Here's my email address. As long as you send things to this email address, they will be considered delivered when they are sent. So that's a brand new concept for us. It is optional. They're on the last page of the contract where the agents put their information. There's a place for them to put their email address and provide that designated electronic address if they choose to do so. I'm kind of waiting to hear from our members how often that feature gets used, and if they like it or not, but it is a new option we have for them. Oh, and this is just jumping to page 16. This is where they would do that. So it's after all the buyers and sellers sign in the real estate broker section. This is where they would put their designated electronic delivery address if they are consenting to accepting delivery at that email address they're providing. And if they don't fill it in, then it's just back to the other side's gonna have to confirm personal receipt for delivery of notices and things like that. Okay. Oh, yes.
Go ahead.
This is our dispute resolution page. Nothing has changed. Only two things have changed here. One, the formatting. Boxes around liquidated damages and arbitration to distinguish them from mediation, because mediation is always in the contract. You don't opt in or out, it's just in. But liquidated damages and arbitration, the parties have to initial to bring those clauses in. And so we tried to clarify that via formatting. And then there's a new option now. If, for example, if you are advising somebody entering into one of these contracts and they are going to initial and agree to arbitration, and you want to designate what arbitration service you're going to use in advance, there's now an option to do that. If you leave it blank, it'll still just be a mutually agreed upon arbitration service. But if you want to designate it ahead of time, there is now an option to do that in there.
I would note two things, that on the mediation, CAR has, in a bit of self-dealing, identified their own mediation service as the designated mediator unless you select someone else. And this other thing is that there's a provision in here that the agents can, after the fact, when a dispute arises, decide that they want to be a party to the dispute resolution, but they have a separate right to do that, and they can do it later, whereas the other parties are going to have to agree to it, obviously, when they make this agreement. So the agents have an option to become part of the arbitration after there's a dispute.
Opt in or out, yeah. Yes, and I saw a question a while ago when I asked, when we were talking about like buyers getting reimbursed if the seller leaves items behind and things like that. And someone said with that, they have to go to mediation or arbitration for it. Our contract does have a exclusion from mediation and arbitration for anything that falls within the jurisdiction of small claims court. So hopefully that kind of thing, worst case scenario would be a small claims court type dispute, those smaller things, but it's only for matters that exceed small claims court jurisdiction when these provisions kick in and become binding on the parties. All right, almost done. And I know we're just about out of time here. So sort of the last thing I wanted to point out was new signature blocks, new concepts for dealing with entity buyer and sellers. You no longer have to use that additional form, the representative capacity signature disclosure that we've had for a while now. If the buyer or seller is an entity or acting in some sort of representative capacity, there's now just a box to check. And then there's a ability to sign, the individual on behalf of the buyer and then print the signer's name and title underneath. So trying to give a little bit more flexibility with the signature blocks than we've had in the past. And we have that for both the buyers and sellers side.
Yeah, I'm sorry we're going over a tiny bit. There are one or two things I thought should be, I wanted to point out to people. In section 8A, 8A2, there's some potentially difficult provisions regarding, failure of the appraisal contingency or problems in getting insurance. And the way this form is drafted, you may have already waived your contingencies, but then your lender comes in and says, we're not making the loan because of the appraisal, because of, for some reason you're having trouble getting insurance. And we've certainly seen fire insurance getting canceled or companies that won't write. And I think 8A in some places has some difficult provisions for the buyer where arguably they're still supposed to perform, but their lender won't give them a loan. And another problem with that is, and this is, I think was a problem probably in the prior form in section 16, you have a final walkthrough, but it says it's not a contingency. But you're supposed to have the final walkthrough to make certain the sellers perform the things they had to do before close of escrow. And if you find out that they haven't done them, obviously you shouldn't have to go ahead and close escrow, but the form says they're not a contingency. So I think that creates some ambiguity and potential problems as well.
Yeah, that, like you said, that's been there and has been a point of contention for people for a while. I think now, at least arguably, the buyer could, give the notice to seller to perform, to complete that repair. And then if they want it, they might not have a contingency, but maybe contractually could walk away for non-performance. But yeah, that has been an ongoing issue.
I think as a final comment, I want to congratulate CAR for preparing the form with the grid, with the boxes, trying to put all the things together that are contingencies. It's very useful to have those all in one place. I do think it's still very strange. When we're lawyers, we write an agreement that says this is an agreement between seller X and buyer Y, and we still don't have the seller identified until the signature page of this contract, which is really strange to me. And I understand it's an offer and so-and-so is making an offer, but usually you'd say they're making an offer to somebody and not have that show up on the last page. But in general, I think it's probably a big improvement. I've heard positive comments from the agents that I've talked to, and a good job to get something done, although we are getting pretty lengthy. We have some questions in the chat.
Sure.
We're under our time by about 8 minutes, but
yeah. And I was just gonna say, people can email me. I'm happy to take emails. My email is janag@car.org. That's it, just my name, janag@car.org. So if we didn't get to your questions and you want to reach out, that's how you can reach me.
And just so you know, there's 3 people that CAR has doing these lectures. The head over there, Gov Hutchinson, Neil Kalin, who has been on the form writing committee for a long time and was frequently our speaker, and Jana. So you have one of their 3 authorities here. And we're really, really thankful for you joining us and giving us such a good presentation and a great PowerPoint and that you put together. And thank you so much. I'm going to have to ask the other people with questions in the chat to send those to Jana, or if you want to send them to me, we'll figure out getting you an answer to your questions. And thank you for such an important presentation that we really appreciated.
Thank you for having me. I was happy to be here.
And sorry we didn't get to all the chat questions.
Yeah.